Hi there, Ariel Overstreet Adkins, attorney and founder of Bluebird Law in Billings, Montana, here today to address a frequently asked question. That question is, what is a trust? Think of a trust as a will substitute in that it can determine the disposition of your assets after your death. But trust can also be very useful during your lifetime. There are a number of different kinds of trusts. Trusts can be revocable or irrevocable, and they can have general or specific purposes. They can be set up while you are alive or upon your death through your will. But the type of trust that I most commonly talk with clients about is a revocable living trust. These types of trusts are set up during your life. They take title to your assets, and they offer great flexibility for management. The simplest way that I explain a trust to my clients is to encourage them to think of their trust like a box. So go ahead, imagine a box. Now, there are three key roles associated with the box: the settlor, the trustee, and the beneficiary. And the settlor, you may also hear the term grantor, is essentially the person or people who make the trust. And so they are the people who put things into the box. The trustee then is the person who manages the stuff in the box. And the beneficiary is the person or the people who benefit from the stuff in the box. So usually the people who create a living revocable trust serve in all three roles during their lifetime and while they're capable to act in those roles. So they put the stuff in the box and they manage the stuff in the box for their own benefit. Now, while they're alive, they can take things out of the box. They can sell those assets, they can buy new assets, and so forth, as if they own those items outside of the trust. Trusts are an excellent tool for planning for the smooth continuation of financial management in the event of incapacity and not just death. Because if you become incapacitated, you will have nominated a successor trustee to step up and manage your assets for your benefit, usually without really skipping much of a beat. Then, when you pass away, the trust can be administered outside of the probate process. Many people like this aspect of a trust because it maintains privacy. So instead of filing a court case with details about assets and beneficiaries that are open to anyone that can access the court record, a trust can be administered outside of court with the help of an attorney in the privacy of their own office. Trusts are especially worth considering if you own property in more than one state, in which case an ancillary probate may be required. So you might be facing two probates or multiple probates depending on how many states you own property in. For probate avoidance, the most important thing with a trust is to make sure that it is properly funded. That is, ensuring that you title all of your property in the name of the trust. So that's a trust in a nutshell. I invite you to schedule a free 15-minute consultation with me to discuss your situation and how we might work together to meet your estate planning goals. I hope you have a great rest of your day, and we'll see you next time.